We are on the record. Good morning. This is a continuation of the rulemaking proceeding in docket RM72.
Excuse me. I'm sorry. I'm the videographer. I didn't realize we were starting so soon. I need to record the audio. I apologize.
Okay. Let me know when you're ready.
Yes, sir. Okay, sir, we're good.
Great. Thank you. Thank you. This is a continuation of the Commission's rulemaking session in docket RM72. Before we get going today, are there any preliminary matters that need to be addressed? Seeing none, when we last left off yesterday, there were a few remaining issues that we were going to revisit this morning before looking at other proposed revisions. We'll begin with staff. Good morning, Mr. Chen.
Good morning, Mr. Chairman. So yesterday, when we were walking through the four major issues, the conclusion of issue number one, you had asked staff to see what we wanted to do, what could be done with the generating unit definition, because that seemed to be a definition within a definition and nested within a definition, excuse me. So staff is prepared to propose breaking that term, generating unit, out as a standalone definition. This morning I had circulated to Ms. Best staff's proposed language for that. It does involve a little bit of tweaking because now we need sort of like to set the definition. So staff is prepared to go through that now or during the walkthrough, whichever is your preference. And then the second point I'll just mention is staff also does have, did its homework and does have language to address Commissioner Linton's phrasing concern with respect to COMAR regulation 2079-01-10A.
Thank you, Mr. Chen. So it sounds like staff is creating simply a new definition of generating unit.
That is correct. And if I could ask Ms. Best to pull up the regulatory document, the master document, I would be happy to take the commission through staff's proposal for this term.
Thank you. We'll have Ms. Best bring up the document. And Mr. Chen, your microphone is a little bit scratchy today, just FYI. There we go.
Okay, is this any better, Mr. Chairman? If I get closer? Fantastic. Okay. So while she is getting, when Ms. Best is getting to the portion, no, okay, so we are here. So following the commission's revisions yesterday to the term generating station, we are keeping the term generating unit, but we are making that now, proposing to make that now its own standalone definition. So what you see on the screen as a little c will now become its own term, broken out under generating station in alphabetical order. So it will now become definition number 24. Staff's proposal is for the term generating unit means the component of a generating station that produces electrical energy and contains a separate electrical isolation device to prevent the flow of electricity when required for operation or maintenance. B, separate energy measurement meter. C, separate inverter if applicable. And D, the ability to be operated in an independent manner from other generating units.
I'm sorry, Mr. Chairman. Is the screen cut off for other people as well, or is it just my?
No, I can't see it either.
Oh, okay. Yeah, maybe you can shrink it just a little bit because I'm only seeing half the page. Sorry. Thank you.
What I'll try and do is I'll try and copy it into the COMAR now so you can see it better.
Yeah. So we're only looking at the pink box. Commissioner Richard, you can't see the pink box?
Mr. Chairman, all I see is a notice that host advisor is starting to share content, and I got a blank screen.
Okay, Commissioner O'Donnell, you have a different problem than Commissioner Richard, I believe. The content has been on the page for about a minute or so. Let me see if Commissioner Richard, you could see some of the language.
Yeah.
Okay.
Yeah, I guess I can see now well, am I supposed to be looking at the pink box or am I supposed to be looking at the text?
Just only the pink box. Ms.
Okay.
Beth zoomed in on the pink box, which was the definition, but she just
Okay.
posted it in the document.
Got it. I'm all good now. Thank you. Sorry.
Okay. And Commissioner O'Donnell, you can't see anything. Is that right?
I can't see anything except the notice that the host advisor is starting to share content.
Okay. I'm getting a message on my screen that your connection is not stable. Perhaps if you log out and come back in, we'll.
All right, give me a second. Don't let me hold it up. Keep going.
Okay.
So, Mr. Chairman and Commissioners, there's not a whole lot there's not too much that's different for this term generating unit. The core elements, that's little a through little d, as in David, they were carried over from staff's original proposal, so that hasn't changed. What staff did was add a little pretext at the beginning of the phrase generating unit to set it up. So now generating unit means the component of a generating station that produces the electrical energy and contains, and then it flows into the 4 elements that are carried over from staff's original proposal.
Thank you. Let's see if commissioners have questions. Commissioner Linton.
Mr. Chairman, thank you to staff for doing a little homework with this. First, let me take it from a house cleaning perspective. This term generating unit, do we use it anywhere in the regulations other than in the definition section right here? I just did a quick word search for it and I only found one other spot in let's see, we're not in the section now, so Ms. Best, I'm not going to ask you to go to it because it's further away from where we are, but it's all the way out in the section 06. And it's just part of it's 06, excuse me, 07 actually, modifications to the facilities at a power plant. And it's just part of section B. And I don't know if that means that that section references something different from what we're talking about now. But aside from that, I don't see that we use it anywhere else. So I guess my question is the term, just from a housekeeping perspective, not talking about the need and for other reasons, but just from a housekeeping perspective, is it necessary?
Good morning, Mr. Chairman, Commissioners. This is John Borkowski for staff. The only other place besides the location referenced by Commissioner Lent that it is proposed to be used is in the definition. The definition of generating station currently today just references a unit. Unit is undefined, so adding generating unit or adding generating in front of unit in the definition of generating station would be one precursor, and then we would define what generating unit means in this new definition. So it's really just cleanup for the most part. But I do think that, it's probably important with how highly configurable these generators are these days that, we have at least some minimum definition for what's considered a generating unit. So that's, again, although we're not going with the 1 mile rule, we'd still like to go with, just defining a generating unit because it heretofore is undefined.
So thank you, Chief. Thank you for the answer. So I guess that goes back to my question from yesterday then. Is there a difference between a unit and a station? Or is there really just a case where maybe a generating station just encompasses a unit? So perhaps this definition for station needs to be revised a bit to incorporate what we're pointing out as a generating unit.
Yeah, Commissioner Linton, in response to your question, the way staff considers generating unit as compared to generating station, a generating station can contain multiple generating units. So in that way, it's not circular to have two separate definitions.
Sorry, I'm getting some feedback on my microphone here. I'm going to turn it off for a second, make sure I'm not disrupting.
Commissioner Linton, did you hear my explanation, or should I repeat it?
If you could repeat it, I appreciate it. I think I thought I heard most of it, but it might have been the piece you said at the end that I missed.
Okay, to repeat what I understood the question to be was, how is a generating unit different than a generating station? And, to my interpretation, a generating station can contain multiple generating units. So the two are not the same, and therefore adding a definition for generating unit and also having a definition for generating station, would not be a circular type of thing. It's two separate definitions.
Okay, thank you. I did hear it at that time, Chief. So, and I appreciate that. I had not been reading the regulations up until this point to see it as two different things. There's generating station appears multiple times throughout the regulations. So I don't know if anybody knows the answer to this at this point, but are there points throughout the regulations where we're referring to multiple stations, multiple units rather, when we should be just referring to one? I mean, I guess I'm wondering if we're starting to open up a bigger box here that we're creating the box and then opening it by creating the definition.
Commissioner, if I might, Lloyd Spivak for the commission staff. The distinction between a generating station and generating units has existed for a long time. It certainly has been present for a long time in usage with respect to fossil fuel plants. For example, you'll see a traditional coal plant might have six different units, each of which is a separate boiler and a separate chimney. It would probably be useful, regardless of where else it's used in the regulation, to have the definition of a generating unit in COMAR. So, if there's ever any question about what's being referred to, it's there.
Mr. Spivak. So let me take it from a different perspective. Then if you take a look at the scope section, which is all at the top, 0.01, and again, Ms. Bess, I'm not asking you to go there. Oh well, it's fine. If you look in section A, it says a person applying for a certificate of public convenience and necessity for the construction of a generating station. So now we're talking about, we created the definition now for a station that's not a generating unit. So are we saying now that these regulations apply only to generating stations, so it's multiple units? Or is it just one unit?
I think generally speaking, the only time you would be getting a CPCN for a separate unit of a generating station is when you have an existing station that's being expanded and you're modifying the existing CPCN. So, I mean, from that perspective, you're covered in the statute. But Mr. Borkowski can add if he thinks there's something additional that needs to be added to that.
Yeah, this is John Borkowski for staff. I really don't have anything else to add here. I think that we were just trying to take an undefined term in generating station and define it. And we felt it was a good idea in particular because of the highly configurable nature of these generating units that are coming onto the system these days. So that was the only motivation here.
So I appreciate that, Chief, and I'm not trying to remove the need to make sure we identify those types of projects. I just don't. The confusion that I'm feeling now, and as an attorney trying to read this, what could result to be a lot of technical differences. I'm just trying to make sure the regulation doesn't create that for somebody else who may not have had the benefit of these conversations. So that's all I had, Mr. Chairman. I don't know if I've helped any, but I'm not sure. The generating station appears in a lot of places, and if we create a new term that means something a little different, it only appears once. Again, I don't want to lose what the chief is trying to mention as the uniqueness of the different projects that could be out there, but I'm not sure we're capturing it and doing it this way.
Commissioner Linden, if I may, you did mention the reference to the term generating unit in COMAR Regulation 07, which has now been renumbered to 08. And certainly from a big picture standpoint, these regulations under this title do apply to generating stations broadly, but they also apply to modifications of generating stations, which could occur at a single unit level. So, Regulation 08 does contemplate any changes to an electric generating unit or other facility at a power plant. So it does consider the fact that there could be modifications that go to for example, if you're talking about a natural gas facility, a combustion unit itself, or could be modifications for other aspects of the facility. So even though currently there's only a single reference under 08 and not elsewhere in the other chapters, I do believe, and if I heard correctly from our chief engineer and staff counsel, that it would be beneficial to at least have this term in place. Give a little bit of give some clarity as to what the generating unit contains, and then there is, of course, the potential of building off of that future regulations. We don't know where the discussions will lead with respect to yesterday's concerns and aggregating net metering, but it could very well be that the result of that may produce regulations that do utilize and reference, generating units. So it would be helpful to have this.
Commissioner Linton, if I may. I did find that the definition had more utility when we were contemplating the 1 mile rule, although the 1 mile rule has now since been put to the wayside. I am concerned with including additional definitions that will not generally or commonly be used, but in this case, I will defer to staff's expertise for the need to separate the unit from the station. But I do hope that this doesn't cause more confusion than clarity for those who rely on the COMAR.
Can I ask a question along these
Commissioner.
amended to this discussion? So, Chief, if we were going to add a third unit at Calvert Cliffs, there's 2 units there at that nuclear generating station. A CPCN would be required for unit 3, and it would be defined by this definition, correct, or not?
Well, thank you, Commissioner Donald. The CPCN would be required for a change to the generating station, but to your point directly, yes, a third unit at Calvert Cliffs in your hypothetical scenario would be considered a generating unit that is part of a generating station.
So that's helpful for me to separate this. Now, my follow-on question that arose during this discussion was all of the discussions yesterday about adequacy of the application or completeness determination. And we changed what you can and cannot do in that section. For instance, now that the commission has agreed to preclude once a decision on delegation has been made from getting any more information that wasn't on the checklist in the determination phase, that would apply to a unit 3 at Calvert Cliffs. Is that true or not true? In other words, these regs aren't, let me state it another way. These regs aren't just for utility scale solar. These regs apply to every generating unit out there and every scenario and situation out there that might be much more complicated than a utility scale solar generating unit.
Commissioner O'Donnell, if I can answer that. Yeah. I believe the short answer to your question is yes. The requirements, if they're adopted under the completeness determination regulation 10, would apply to the modification of the generating of a single generating unit at a generating station.
I think that's helpful for my thinking and maybe for the commission's thinking, that as we look at the modifications to these regulations, it's not just the solar component of our CPCN process. We're affecting everything out there with this. And it wasn't clear to me until just listening to Commissioner Linton's colloquy with Chief Borkowski that was true. I was pigeonholed into thinking we were modifying this stuff for solar. It's not just solar, it's everything. And I hope, maybe I'm the only one that was pigeonholed in that thinking, but I think it's a different light that you have to put on these changes.
Well, to that point, Commissioner O'Donnell, one of the things that's also part of the picture of all of this, how all of this fits together, is PPRP's responsibilities in all of this. If we can, just looking at regulation 10, which goes to the completeness determination, that is a 45-day window for PPRP to conduct its and issue a letter of completeness recommendation to the commission for not just solar facilities, but also for a modification to an existing, fossil fuel or even nuclear facility here in the state. So that, and the fact that, it's been a busy legislative session, and there has been a bill that is moving through the legislative process right now that would further put on to the state agency's review, sort of like defined timeframes. These are very, very valid and legitimate considerations. But I would say, though, you know, again, the focus of the regulations here, if staff is trying to target sort of these key milestone points in the process, and that completeness review is a significant one where, you know, we hope that the regulations will kind of loosen some of this bottleneck. But in the event that, you know, we don't know how, you know, once the regulations do get adopted, time will tell how effective they are. So if there are as a need to come back and revisit that language in order to accommodate some of the challenges that unforeseen challenges do arise, I'm very confident we can do that.
I'm confident we could do that too, but my point is this, Mr. Chen, the whole discussion yesterday on putting limitations on the commission to ask questions during certain sequences of the completeness determination, or not to be able to ask them later and have to wait until the merits phase, or the whole notion that we may not be able to use use certain information in a certain way or modify procedural schedules. All of that affects, the whole discussion yesterday was focused on utility scale solar and the coalition, but it affects a much broader array of technologies. And we didn't discuss any of that yesterday and how it may impact our CPCN process and the public interest. And I just wanted to point that out for the commission's benefit, because I think it's substantial and important. We're focusing on a certain group of folks who want to reduce their timeline, but it may not be in the public interest for other technologies. We can discuss it.
I do have a follow-up question for the commission. I do remember that the commission did discuss and move on from the coalition's first added recommendation, which is you know, that failure to include information not on or not expressly enumerated under Regulation 06. That's the application filing requirements, should not be grounds for an incomplete determination. But as to the second, and arguably the more concerning recommendation, which is that estoppel argument that goes to preclusion of you know, the ability to modify the procedural schedule and even deny the CPCN. I don't recall the commission actually moving on from that, except just to allow the coalition to come back with some language to correct the, you know, the sort of defect in how they phrased their or worded their recommendation. Am I correct?
We're going to get to that proposal next after we get done with this. Mr. Bugelman was given an opportunity to bring that issue back to the commission.
To put an end to my discussion, Mr. Chairman, I kind of like having a separate generating unit defined as it applies to other technologies. I think it's an important step forward. Staff's recommendation seems to be a pretty solid one.
Thank you. Other commissioners on the generating unit definition.
I'm fine with having the definition for a unit.
I agree. I'm fine with having a definition.
So, Mr. Chairman, I'll make it 5 for 5. I'm not going to stand in the way of having it as a separate definition. I think it's better that way than having it as a nested one. I am a little concerned about creating it now without really thinking through whether or not it needs to be, whether or not there's other issues here that we need to address for units as opposed to stations, but we can leave that for another day.
Thank you. And hearing no concerns raised by stakeholders in this proceeding, the commission gives its consent to this new definition. Mr. Chen, did you have any other remaining issues before I turn to Mr. Bugelman's?
Yes, Mr. Chairman. Commissioner Linton had asked staff to take a look at, see if we could reword the phrase "keeping it at the commission" that you find in COMAR Regulation 2079-0110A. Thank you, Ms. Best. So what you see here in the comment bubble to the side is what staff came up with as an alternative.
Okay, hold on 1 second. So Ms. Best, your full screen, if you could just shift a little to the right for some, oh, she's putting it actually into the language. Thank you. Some of us were looking in the comment bubble, but the new bolded in red font appears to be staff's proposal. Okay, Mr. Chen.
Okay, so to arrive at this, I just want to give a description here that might help set the context. I looked at all of the solar CPCNs that were docketed since 2011, and I looked at all of the non-solar CPCN matters that were docketed with the commission also since 2011, and in every instance, the matter was delegated to the Public Utility Law Judge Division, with the exception of one, I believe that might have been the Dominion Cove Point. However, also in most cases, not for 100%, but I would say 90 to 95% of the cases, the commission issued either a letter order or a notice to the parties docketing the matter and delegating it to the PULJ. So in an effort to try to clean some of this up, staff feels that it's a little bit more straightforward if we rephrase this slightly to say, you know, after the application has to construct, the CPCN application has been filed, and within 45 days after the commission has issued an order docketing the matter for delegation to the Public Utility Law Judge Division or consideration by the commission, comma, and then the rest of the clause.
Okay. Let's see if Commissioner Linton, does this address your concern for clarification?
It does, and I thank the staff for taking that homework on. I think the only thing I'd add is that in the first version, you had the word either in there, and I think you should still keep that. So it's just to say in order, either docketing, but other than that, it's fine.
Right. Ms. Best, do you see that? An order either docketing the matter? Oh, was that it, Commissioner Linton, or you wanted the word either? Is that right?
Either in the new, I guess, darker red underlined. Yes, right there.
Do other commissioners have any concerns with this amendment? Hearing no concerns from commissioners or from stakeholders.
No, Mr. Chairman, I don't have a concern, but I think Ms. Best, you have to delete there and order and down to keeping it at the commission, just to make it accurate. There you go. That was all, Mr. Chairman.
Thank you, Commissioner. Right, Mr. Chen, other items holding over from yesterday?
Not from staff's perspective, Mr. Chairman. Thank you.
Thank you. Mr. Bugelmans.
Thank you, Mr. Chairman, Commissioners. David Bugelmans on behalf of USEC. I also have with me virtually again, Mr. Cyrus Tachikori, the chair of USEC. After the hearing yesterday, we discussed our proposed addition of Section E to COMAR 2079-0110, both internally and with counsel for PPRP, Ms. McLemore. We do appreciate the chairman's offer to come back with a revised proposal this morning. But what we've decided is that based off the text adopted yesterday, including the addition of a new Section D, we're willing to withdraw our proposal for Section E. Again, we believe the rest of the changes adopted by the commission to this part of COMAR go a long way to addressing our concerns. And overall, we're much more in agreement with staff and PPRP than we're not. So for those reasons, we're fine withdrawing Section E, and hopefully that resolves the issue.
Thank you. Do you have any other holdover items from yesterday?
I do not, Mr. Chairman.
Okay, well, we'll now begin with what I'll call the second half of
Mr.
this.
Chairman, Mr. Chairman, excuse me. Before we move on, can I ask another question in this section we were just in that Mr. Bugelman was talking about? Could you go to C, Ms. Best? Can you go up a little bit further? Okay, thank you. That's all. I don't have a question.
At this time, we'll proceed, Mr. Chen, with your continued presentation.
I do want to point out, Mr. Chairman, I'm sorry, I do want to point out, Ms. Best, if you could scroll down, yesterday's discussion about the first recommendation from the coalition, that is not reflected here. I just want to make sure that Mr. Bugelmans, are you withdrawing that one as well?
Chen, what are you referring to?
So yesterday's discussion, the commission voted a 3-2 majority that they would adopt, go with the first recommendation from the coalition, which is, and I don't have the language entirely in front of me here.
That's exactly what I was looking for to ask a question about, and I couldn't see it.
Yes, it goes to the effect that a application failure, I'm sorry, something like failure to include information that is not listed or outside the scope of, not listed under COMAR Regulation 2079-0106 shall not, it cannot be grounds for a determination of incompleteness.
Yes, you're right. That section, which I have on my draft, is not on this draft. It may have.
I think it might have been dropped inadvertently, but I'm sure the coalition can provide that language. We can clean that up.
The language states a CPCN application shall not be deemed incomplete for failure to provide information that is not required by COMAR 2079-16. Instead of accepting that proposal, perhaps it was clicked rejected, and that's why we don't see it here anymore. So I suspect that.
I'll make a note and we'll add it back in during one of the breaks.
Can I go ahead and ask my question about it then, since we've at least
Please.
found it conceptually? Mr. Chen, when 06 was developed, the checklist in 06 was developed, was a project like Cove Point, a very extensive $4 billion multi-year CPCM modification, was that project that was very complicated considered in the 3-2 decision language? Because that's a situation, I wasn't able to articulate it quite well enough yesterday, where you don't want to hamstring yourself from being able to get as much information as possible for as long as possible. Was that kind of project thought about? Or maybe a third power plant, a small modular reactor located at Calvert Cliffs? That's very complicated. Was that list in 06 made up with very complicated projects like that in mind, or modifications to CPCM? Mr. Chen, you're muted.
My apologies. Thank you, Commissioner Don, for the question. When we were engaging in discussions with various stakeholders, we did not go to the specific project level. So we did keep discussions at a very, very high level, but the level of detail, though, just as a general rule, was important to be discussed. And so from PPRP's standpoint, I'm glad that Ms. McLemore here has activated her video. It was important that all of the careful environmental, natural resources, socioeconomic information and those impacts have to come in with the filing. But then as a way to contour the discussion for the purposes of the checklist, we did discuss that the checklist intent was just to come up with a list of documents and information that could get the state parties and the commission going with its review. So in other words, you know, what do you need to get through the gate to the actual substantive review? At no point did any of the parties, and I don't believe, and I'm going to be careful, but I'll risk speaking on behalf of the coalition. I don't believe any of the parties, including the coalition, envisioned that there wouldn't that this checklist was not in would somehow prevent the commission or any of the parties from requesting information through data requests in the full on review process.
I understand that, but I'm talking about not the merit phase, but the completeness determination phase. And we limited the commission's ability there to a certain degree, and PPR's ability yesterday by a very narrow 3-2 split decision. And my question is, would a very complicated project like Dominion Cove Point turning into an export facility and new liquefaction, you know, $4 billion in multi-years and very, very complicated, be possibly constrained if certain questions or information wasn't provided per the checklist, but was deemed necessary anyway, and we couldn't get it. It was too late. We're in the merits phase.
Okay, so in a moment, I'm going to turn it over to Ms. McLemore, but even though we didn't discuss the Cove Point project specifically, the intent of the checklist was never meant to be prohibitive or limiting on the commission to receive information, but that again doesn't specifically stop at the checklist point. But
well, it does for a determination. If you don't think you have all the information to make a completeness determination, and you now have to wait to the merit phase to get it through a DR, the process has been changed, and it's been changed significantly.
So, Ms. McLemore, if I can invite you to add on to my comments.
Yes, Commissioner, I do agree with you, and I apologize for my ineptitude yesterday for not explaining that this CPCN process does include all the types of CPCNs, transmission cases, all types of generation cases, and that is why PPRP was so concerned about this. And Mr. Chin is correct. So the information, we can still obtain the information through discovery, but now with the certain time frames, that was our concern, because once you get a complete petition, once you get a complete application, another clock starts ticking on PPRP, and that is our concern. That is why I was requesting that you oppose this addition. But to answer your question, whether we considered other types of generation in developing our recommendations, yes, we did. We did, and we tried to be as inclusive as we could think of as far as like what we required when we were looking at an application at the beginning. However, sometimes things do get through. Like you said, Cove Point was a very complex and different type of case, and those type of cases do come up sometimes.
I appreciate that. I doubt if the commission is going to reconsider this item, but I think it's important to at least understand the potential impact that we're having beyond the solar coalitions.
One thing I would add also, now that we are waiting until we have a PULJ or until the commission is actually hearing the case, it will be helpful because we will be on that in discovery. PPRP will already begin to do discovery on any unique issues, and we will have someone that will be able to help us in the event that we are not able to get that information, even from the beginning.
Thank you, Ms. McLemore. Mr. Chairman, I'm not going to move for reconsideration here unless another commissioner who voted in the affirmative wants to speak up and change their mind.
Does any commissioner wish to move for reconsideration? Hearing none. Mr. Chen.
Okay, thank you, Mr. Chairman. So I believe we are ready to proceed to the walkthrough or phase 2 of the rulemaking, where we take up the rest of the items in all covered through all 3 chapters. So
Do you have a slide?
I do not. Staff does not have a presentation for the remainder portion of it. I think in discussing logistics with Ms. Best, we agreed that we could just simply scroll through the master document. So the first part, Ms. Best, we can hit the definitions. Thank you very much. So the commission has already addressed staff's definition for generating station. I will note that because the commission declined to adopt the 1 mile provision under what was formerly proposed as subsection D, the commission does not need to adopt a separate definition for the term electrical generating equipment. So I know we're not on that yet, but I just want to mention that up front. I don't think I need to go through, or I'm just trying to think of the best way to move through this efficiently. And rather than going through each definition and just reviewing the text of each definition, I'll just stop and say that I don't believe these other stakeholders have objected to any of the remaining definitions under Regulation 02B.
Chen, why don't we ask the parties at this time, do any parties have any concerns with the regulations? There's about a dozen regulations specifying new or modified definitions.
Chairman, if I may, Janet Christensen Lewis for Kent Conservation Preservation Alliance.
Good morning, Ms. Christensen Lewis. Yes.
My concern, and it's a little complicated, and so please bear with me. My concern is for the definition where I think you're asking, can you scroll up to the next? I'm sorry, I don't have it right here in front of me. No, I'm sorry, down, not up.
Do you know what number or what word we're defining?
It's the next, it is about the, oh, wait, stop. Complete application. Okay. You're defining the complete application and what has to be included in that. And it refers to COMAR 2079-0106, which states that at least one attempt, part of the completeness application is that one attempt to engage the affected communities to regulations of 04B, which is the regulation that I'm concerned about. And the other issue that I'm having is that the definition of affected community is excessively narrow when it comes to, for instance, an organization may not have within a county, may not be within a 1 or a 3 mile radius of the generation station, but has reach into within 1 mile of the generation. And when I say that, I would say something like the river keepers in Kent County may not be within a mile of a generating station, but their purview and their mission is to protect rivers all over the place that may be within 1 to 3 miles. So it's not their community of people who care about the rivers are being impacted. And the same thing with Kent Conservation Preservation Alliance. Our physical address may not be, we may not reside or be in this 1 to 3 mile radius, but our mission of protection of historic and agricultural resources spans the entire county. And we have members that would in fact live, as the riverkeeper would, live within the 1 to 3 mile radius. So then we get back to 4B, and what is under 4B, excuse me, requires a lot of things. I have it here in front of me. 4B requires, and this specifically, this regulation is prior to filing an application. It says that specifically, that they have to notify the commission, A, and B, offer to engage the public, and at a minimum, the following actions, which is to designate a community liaison officer, identify actual community members and community organizations within the affected communities, hold a minimum of one public meeting. The public meeting shall include, and then you have A, B, and C, which are things that the public utility law judge schedules after the application has been filed. This is not done pre-filing. What is held here are things that are done by the public utility law judge in the scheduling post-filing. So I'm a little confused, number one, by the regulation, but number two, I'm concerned that these steps are not being taken. And so I know this may not be the correct place to put this forward, but I'm not quite sure where to intervene in this process to put forth my arguments that there's a problem. And the reason that I consider it to be a problem is because if the agencies within the affected community, if the organizations that are standing up for certain important issues within their community are not recognized and not contacted, they have no way to contact their members in order to get it on the record even before a application is filed, let alone be able to know that the process is even undergoing. And I put forth the MD Solar One as a prime example of what happens, but it happens routinely. You just don't hear about it. That was a case that got publicized because organizations were not notified, people were not notified, and did not know this had happened. So I would just say that something, first of all, this regulation, is it true that prior to filing an application that the applicant has to hold a minimum of one public meeting, and that the meeting will be scheduled at least 60 days before filing of the application, and that the applicant shall provide notification of the public meeting and place a meeting on the applicant's website or on the applicant's parent company, or place a meeting invitation on at least 2 types of social media platforms, publishing an advertisement, providing a copy, and the applicant shall take steps to accumulate reasonable requests. And on top of that, if you are an organization or a member of the public and you don't know that there's a project coming forward, you would not know to look in your paper, you would not know to look on the applicant's website, and you would not know to look on social media platforms.
Christensen Lewis, so you just asked if that was true, and you read the regulations that are on page 8 of this document in Regulation 4, and yes, those are regulations that the developer must abide by in conducting outreach with the community. You paint an example for us where not everybody in the state or in the county would be notified of a potential project, and I would agree with you. Not every single resident and organization in a county or in the state will be notified every time a particular CPCN application is imminent. I think that would be impossible and unduly burdensome on the developer to make positive contact with every conceivable affected individual in a particular area. They do post these notifications via public notice in a newspaper of record. Now, granted, oftentimes folks aren't reading the legal notices in a newspaper, but that is what is required under the regulations. And I'm struggling to see what more you are asking for the developers in terms of outreach in our regulations.
I'm stating that this process that is in the regulation under prior to filing an application is not happening. And I would like, if it is happening, I would like some examples of how it has happened, because, and I would also like that I don't expect the entire state to be notified, but organizations that are within a county that have shown an interest in the CPCN process related to generation applications, CPCN process applications, should be included and I mean, they don't even have to identify us. We exist at the county level, and we have members that live within 1 to 3 miles of these generating stations, and never, from our experience, have we been notified about having public meetings before pre-application.
To the extent that occurs and a developer is in non-compliance or violation of the regulation, and these individuals that are in close proximity to the proposed generating station do not receive notice, that should be brought to this commission's attention.
I might just to add a clarification. I think to the extent that this has not happened previously, that's why we're here, to make sure that it does happen in the future. That's what these regulations are intended to do at this point. It's not recording what has happened. It's setting new rules for going forward.
But
I would like to respond to this, Your Honor, if possible, based off my experience with notices for these cases. So I think there's one important thing to clarify here, Your Honor. I think some of these notice requirements that Ms. Christensen-Lewis is referring to apply only to qualifying generating stations, which my understanding is those are fossil fuel plants. So some of these pre-application requirements for community meetings, things like that, I think, first off, they're newer regulations. And with respect to solar, I don't think they apply. With respect to the notices of applications, as the chairman said, the requirement is to publish for public comment hearings 4 weekly notices in a local newspaper, publish each week in 2 forms of social media for 4 weeks before the hearing, notice of the hearing. I agree with the chairman that I don't think it's a reasonable expectation to be able to notify the entire state of these applications. But in my experience, generally, especially by the end or by the first public hearing, the community generally is aware and people do attend and participate in these things. But I can tell you that developers do take these notices seriously. We have to submit compliance filings showing we've complied with these requirements. In the one case where there was an issue with one, we actually canceled the hearing and rescheduled it. That was a few years ago. So it is taken seriously. I just want to make that clear that, compliance is occurring with all applicable notice requirements for these projects.
Mr. Bugelman,
Chairman, could I ask Mr. Bugle? I'm sorry. Go ahead.
Mr. Bugelman, could you clarify something that you said, please? And
Sure.
that was, what doesn't apply to solar developments and only applies to fossil generation? What did you say?
So I believe Ms. Christensen-Lewis was referring to the commission's more recent environmental justice requirements that it adopted. And I think that those requirements only apply to what's referred to as a qualifying generating station. And my understanding is those are fossil fuel plants. I wasn't involved in that rulemaking, so maybe staff could correct me, but I think some of those additional community requirements were designed to only apply to certain kinds of facilities and not solar facilities.
Could I state to Mr. Bugelman that Regulation 2079-0104 says prior to filing an application for a certificate of public convenience and necessity for the construction of a new qualifying generation statement, unless otherwise provided under this regulation or exempted under this subtitle, an applicant shall complete the following actions as described. Offer to engage the participation of affected communities for the purpose of educating the affected communities concerning the proposed project and soliciting their feedback. And then it has 1, 2, 3, and 4. And for the meetings that you have just described, where you posted and that you took seriously, have any of those occurred prior to filing an application for a CPCN?
Mr. Bugelmans, I'm sorry. Let me jump in. This is Joey Chen from staff. I was involved with the recent rulemaking you mentioned last year. This was rulemaking or RM69, and you are correct, Mr. Bugelmans, that the genesis of that rulemaking was focused around a fossil fuel. A CPCN that was issued to a fossil fuel facility, which then led to a Title VI complaint filed with the US EPA and the Department of Transportation, PHMSA. And it wasn't just a commission that was involved, there were 2 other state agencies. But out of that process and resolution came the rulemaking. And the rulemaking does specifically focus on and defined in the rules under what we just reviewed, 2079-0102, a new term, qualifying generating station. And that is a fossil fuel generating station that's greater than 70 megawatts in capacity. So the notice issues and the public engagement issues, they were previously addressed last year in the course of RM69. And so those protections, and I do appreciate and understand Ms. Christensen Lewis's concerns, but Mr. Bugelmans, you are correct that Regulation 04 is titled specifically pre-application requirements for a qualifying generating station. So the way that the staff's rulemaking proposal and ultimately the rules as adopted by the commission were to implement a new series of requirements on developers and applicants who are looking to build a large commercial grade fossil fuel plant in Maryland going forward. And that's not just notice and public engagement, but that's a whole other environmental justice screening and those type of requirements that are now added to the application filing requirements of the Regulation 06, but also specifically under provisions broken out later in 2079-03. So those regulations do not, in their current form, apply beyond qualifying generating stations as it's defined under COMAR, this chapter of COMAR. Now,
well,
I'm not sure.
Thank you for that appreciation. I appreciate
I don't know. Okay, we'll just leave it there. I hope that answers your question. It may not be satisfactory, but I needed to confirm some of the details that Mr. Bugelman's put out there. But I don't know if that
it does answer some of my questions. And you're right, it's unsatisfactory because you end up with cases like MD1, where everybody spent a lot of time, money, and energy to follow through with a case. And because of non-notification, and this happens not only pre-application, but happens during the CPCN process itself. In engaging, I know that you think that, you list the cases on your website, they list it, they do all of these things, they take public hearings seriously, but the public themselves are unaware of what's going on and don't have access, don't have the educational access to know that there's something going to be built in their neighborhood and that where they should go to find out what it is. So the process, in my opinion, I mean, for the protection of the PSC and the CPCN process, it seems to me that the commission would be interested in trying to figure out how to better communications. And I know that you've been before the Maryland legislature to try to enhance how notification happens, but it's not working. As a member of the public and as a member of an organization who routinely confers with other organizations across the state, the PSC, and I was hoping that this particular regulation, if it were strengthened, would be able to help remedy some of that. But as we sit here today, and it's only going to apply to certain qualifying generation statements, and wind and solar are not included in that, and I'll have to look at it to know what else is not included, then you are eliminating a huge ongoing controversy in the state of Maryland, and you're causing conflict because people do not have the right to step forward to speak because they don't know about it. I appreciate the time, Chairman, and I guess my question has been answered.
Ms. Christensen Lewis. Additionally, I would like to say that the commission does its best to inform the public of any CPCN proceedings, whether it be large fossil stations, solar, wind, what have you. And we do that on all of our social media networks. We issue formal notices, but we also issue informal notices through our various forms of media. So while the regulations don't encompass contacting everybody in the county, our regulations attempt to contact as many people as possible. And I can attest that we have attended CPCN hearings, myself and the commissioners, where large numbers of interested, engaged citizens show up. Sometimes this is spread by word of mouth, but it only takes one citizen to monitor our Facebook page or our Twitter feed to see when a public hearing is on the horizon. And we typically provide a few weeks' notice before that hearing occurs.
Thank you.
Thank you. Additional concerns with respect to the proposed definitions? Hearing none at this time.
Mr. Chairman, I have a question about prime farmland. And wondering, Mr. Chen, where do we use prime farmland?
Commissioner Herman, I believe prime farmland is referenced in COMAR 270903 in Chapter 3. But I will let Ms. McLemore chime in if she has a more specific reference.
I don't, Mr. Chen. I was just going to say it does come up quite a bit in cases. And I think that might be part of it, but it also, Mr. Zadinsky is also here with me today, and he may be able to provide some insight as well.
I was also able to pull up the section, Commissioner, and it basically prime farmland is there's a new section that's being added that I'm sure we'll discuss later, where the applicant will need to provide a map of the project site, identifying any areas of prime farmland, identifying the area of acreage of prime farmland impacted by the project, and so on. It's actually information that most applicants already provide, which is one of the reasons why we agree with that. But it is referenced numerous times later on in the COMAR revisions.
Okay, I just wanted to make sure that it's a defined term somewhere else that somebody else designates as prime farmland, because originally I saw that prime farmland had like a long definition, and now the proposal appears to be as defined elsewhere. And I just wanted to make sure that we as the commission are not making determinations about whether something is or is not prime farmland. That's somebody else's that's somebody else's area of expertise. That's certainly not mine. And I don't think it's really the Public Service Commission making a determination that something is or is not prime farmland. I think it's okay, and I just wanted to make sure, maybe Ms. McElmore, you can sort of assure me that somebody else is debating, whether something is or is not prime farmland. Some other
Yes,
agency.
yes, Commissioner. The Department of Agriculture was also involved in this. We got affirmation from all the different agencies. And the reason, thank you, Mr. Bugelman, you reminded me why this is in there. It is part of the requirements under a completeness review. We want to understand to try to figure out the impacts of a project, how much prime farmland, and it has a lot of different people mean different things when they say that. So that is why we included it here.
Right. And Commissioner Herman, when you refer to the differences between the two versions of the definition that you saw, the condensing of that, the reference to the technical reference has the language that was previously in the longer version. So if you go to the technical version, you'll see the longer version in the previously filed comments.
Okay, and I like it better with the reference as opposed to, because I just don't want anybody making us decide whether something is prime farmland. So I'm good. Thank you, Mr.
Okay.
Any other discussion on any of these definitions in Chapter 1? Okay, we only have one regulation left in Chapter 1, but before we get to that, we'll take a short break, take a recess until 11:20 a.m. 11:20. We're back on the record. For planning purposes today, we'll plan to have lunch around 1 o'clock this afternoon. Mr. Trout with Potomac Edison, are you with us?
I am, Mr. Chairman.
Mr. Trout, I'm going to call you out of line, and if you're ready to go, we'll address your issue since we're in that chapter and section right now.
Thank you, Mr. Chairman. Yes, I am ready to go, and I apologize if I seem to be sitting in shadow, but I had an internet connectivity problem in my normal location, and I had to move to a different place.
We'll bring up the text of your proposal.
Thank you.
But if you'd like to give us the background as it's being pulled up, you may.
Certainly. As the commission is aware, it has the ability to waive CPCN requirements in certain circumstances, including with respect to existing transmission lines. The scope of the commission's waiver power was addressed in statutory changes that occurred in the 2012-2013 timeframe. And following that, there was a rulemaking, RM49, and one of the consensus proposals in RM49 that was filed by the staff with the commission in February of 2014 was a proposal to create a standing waiver of the CPCN requirements solely with respect to existing transmission lines and solely with respect to maintenance and repair and in-kind replacements. That proposal is the same proposal we are making now, word for word. And it is simply intended to ease the administrative burden for the commission, for its staff, and for the utilities, in that these kinds of projects all qualify for waiver anyway, so that the commission, rather than having to take them one at a time, as has been the practice over the last few years, there can be a standing waiver in the regulations that would deal with all such work. Hopefully the language is self-explanatory. And as I said, this is language that was a consensus recommendation of a commission work group, albeit a commission work group a number of years ago, and was filed by the staff. And we are simply trying to revive it in this rulemaking.
So you've waited 7 years. What happened? Why did the commission not act on this staff recommendation 7 years ago?
I do not know the answer to that, Mr. Chairman. That work group addressed several other issues, some of them relating to transmission lines near military facilities. And some of those items may or may not have been controversial, but I really don't know. The work group report was filed in February of 2014, and nothing happened in the docket after that.
Okay, well, why don't we ask staff then if there are any concerns, or if anybody has the historical memory as to why the proposal wasn't moved in 2014, or if staff supports this language.
Hello, Mr. Chairman and Commissioners. Again, this is John Koski for staff. Regarding your first question about the prior RM49 rulemaking, that precedes my time here at the commission, and I am not aware of why that did not move forward. Now, related to your question about Potomac Edison's proposal, staff did not have a problem with the wording in the proposal. The only problem that we cited was a technicality in that the case caption for this particular proceeding only announced that, you know, this would be related to generation CPCNs and not transmission. So for that reason, we were concerned about proper notice that transmission regulations also be considered. So we basically oppose this on a technicality, but we do not oppose it, you know, from a substance perspective.
Do any stakeholders who have been participating in these proceedings have concerns with the proposal? Okay, that's all the questions I had. Commissioners, Commissioner O'Donnell.
Thank you, Mr. Chairman. So, Mr. Trout, I want to explore how this part of the regulations will interact with the mandatory waiver provisions that already exist. So we have mandatory waiver provisions where transmission lines being replaced or structures are being replaced for a transmission facility. If it's not higher and the conductor size doesn't change and all that, you're familiar with the mandatory waiver provisions I'm talking about, right?
Yes, Commissioner.
So in this definition here, it says similar material structures and equipment. What's similar mean?
I can only offer you the dictionary definition of similar.
Yeah, so it could mean a lot of different things to a lot of different people because there are no limitations. Like the structure may be exactly the same, but it might be 30 feet higher. That's similar, right?
I wouldn't think so. 30 feet's a lot.
How about 20 feet?
I still think that's a lot.
Okay, so I don't, you do. What's similar?
Yep, I see your point. I did not want to change the language, Mr. Commissioner. I did not want to change the language from what was agreed to in the work group and submitted to the commission in the prior rulemaking.
Yeah, so a 20-foot or 30-foot structure height wouldn't get through the mandatory waiver provisions that exist. That's my point. They would get through this new mandatory waiver. In fact, it's already waived, pre-waived.
Oh, well, actually a 20 or 30 foot height change could get through if it wasn't being done to increase the voltage or the width of the conductor.
Agreed. And I don't want to come up with hypotheticals that we can argue or quibble about, but you see my point. I don't want to create a mandatory waiver or a pre-waiver for something that arguably may not get through the mandatory waiver provisions and may have to seek a waiver on the merits.
I understand, Commissioner, and my concern is coming from a different direction, which is given the very broad definition of construction in the statute, we have had to come to the commission for approval to do not really very non-substantive work that didn't involve changing out any of the poles or any of the conductor or changing any of the voltage. It was, dealing with ancillary equipment associated with the line. And we felt the need to come to you about that because of the broad definition of construction in the statute. And quite frankly, the commission seemed to be scratching their heads about why we were in front of them, and the staff certainly was ambivalent about whether we were in front of them. And that was the problem that folks proposed a solution to in 2014, and that I wanted to revive now. There is and your point is well taken that if we were to have a work group today, on this issue, we might be able to come up with better language, or we might not, because sometimes you have to write broadly in order to get consensus. But and I forgive me for a little bit of hyperbole here, but some of us have been very frustrated with the idea that every time we bang a nail with a hammer, we need to come to you all first. I think you've on occasion been frustrated with that too. And we tried to propose a non-controversial solution, and we may or may not have succeeded in doing that.
Yeah, no, I appreciate that, Mr. Trout, and I do agree with the substance of what you're trying to do. Is tripping up on the words for the undefined, similar materials, similar structures, similar equipment, similar locations. I'm tripping up on that particular word, not the concept of what you're trying to do, which I agree with. So, Ms. McLemore, you have anything to add to that?
Yes, Commissioner O'Donnell, we would agree with you. In concept, we completely agree with Mr. Trout. We think this would be a good opportunity to do this. However, the word similar does bring to mind some questions. And we also struggle with this when waivers do come up. And we would be happy to work with Mr. Trout and other parties to try to make sure we can make that language better, or whatever we can do to provide assistance with that.
Mr. Chairman, the alternative in our filing that we suggested, because we knew that this was a proceeding focused on the generation CPCN rules, was to have a separate proceeding and address this and perhaps other issues separately. We stand by our willingness to pursue that alternative route, and if it would be the Commission's preference, we can withdraw this request with the understanding that there will be some work group or proceeding at a future date where people can focus just on this issue and hopefully come up with better language than everyone did 7 years ago.
Mr. Trout, this is like pornography, as Potter Stewart said. You'll know when you see it. I am comfortable with the proposal and the language on the page, although I recognize Commissioner O'Donnell drew some very realistic examples of where two reasonable parties can disagree as to what the word similar or the same means. I recognize we've already been through this process 7 years ago, and you're offering to go through this process yet again. Let me turn to my colleagues to see their positions on this issue.
So, Mr. Borkowski or Mr. Spivak, my question is, your issue is one of notice, is that correct?
Yes, Commissioner Herman. Although we were looking at CPCN regulations, when the announcement went out, it was only captioned as generation CPCN regulation. So again, we don't disagree in substance, but we did feel like there was a technicality about notice.
Right. And I'm wondering if Mr. Trout, if the concern that Commissioner O'Donnell has addressed could be, I mean, are you anticipating that this would just take place and never send anything to the commission? Is that what would happen here?
Yeah, that's how it's written, Commissioner.
Okay. Right. Do you think that this concern about same or similar might be addressed with something like just a letter saying we're doing this? And then somebody can come in and say, hold up, and send it to the staff and the People's Council and say, somebody could come in and say, hold up, that's not similar. You think that, I mean, you wouldn't have to hold off or something, I wouldn't say that you don't do it, but maybe you, I don't know. I'm just trying to see if that might address the similarity, because I I don't know what kind of language you could put in there, you know, because you might replace a wood pole with a steel pole, and one person's view it's similar, and one person's view it's not.
Right. A reporting requirement associated with this, where we file a report either incident by incident or an annual report. God, I just heard myself advocate for creating yet another annual report. I probably should shoot myself right now. But we could file some sort of report, and people could you know, review what we've done, and if they had concerns that could be raised, and that would inform how we applied the regulation in future instances. I will tell you, since Potomac Edison still operates transmission assets in Virginia, I practice in Virginia with respect to this very subject. And it is an issue of some perplexity in Virginia, and gradually over a number of years, the commission and its staff and the utilities there have sort of worked out an understanding among themselves as to what constitutes ordinary and necessary repairs and replacements. That's the operative language in the Virginia statute, and what constitutes new work. That's been painful. We've eliminated a lot of the ambiguity that has plagued Virginia. In Maryland, we've eliminated it in part through the statute, the statutory language changes that have occurred over the years, and in part through the regulations. And this would have been, I hoped, another step in reducing ambiguity. This is a practical problem. We want to try to contribute a practical solution, and we don't want to leave anyone uncomfortable, and we especially don't want to create future problems. But we also don't want to be untransparent. Having made this proposal, I guess I have to live with the consequences of potentially having another report added, if that is a solution that would satisfy folks' concerns.
Commissioner, I would also point out that this is under modifications to the facilities at a power plant. This is not about transmission lines, so that is some of the confusion.
Just John Borkowski, to speak to that, we did notice that problem also, and we had recommended that this whole section be placed in section 09 under waivers and modifications, or at least it never got to be a recommendation because we ultimately decided to oppose it, but should it have gone forward, we would have recommended moving it to another part of the regulations.
Yeah, I'm not sure how I wound up proposing to put it there, other than unless I was trying to follow as completely as possible what was done in 2014. So I may have put it in the wrong place, and I apologize for that. But I agree that it's a waiver provision, and that's where it belongs.
Mr. Trout. Mr. Trout, no, I'm sorry.
Mr. Chen.
Mr. Trout, and perhaps to Commissioner Herman and Commissioner O'Donnell's point raised, if the issue is noticed, would the language be more minimal by, instead of a report necessarily, but allowing or requiring the utility to give, file notice with the commission that it will plan to do this work, some sort of lead time, I don't know, maybe 20 days or 30 days out, thereby allowing any interested party to then respond to that notice with the commission with any concerns about the nature of that work. I mean, it's a different naming, but instead of a report, you'd be filing advance notice with the commission.
Yeah, I thought the notice concern was about the nature of this proceeding, not about notice with respect to the individual work. And if there's a notice of providing, if there's a requirement added to provide advance notice of any maintenance or repair work, that's actually, I think, a step backwards. And it certainly doesn't significantly improve the situation we have now, which is every time we have a project that we think falls within the CPCN waiver rules, we have to file with the commission before we do it.
Let's hear from other commissioners, and then we'll figure out what to do with this, if other commissioners wish to speak.
Sure, Mr. Chairman. I guess the question I would have for staff, they've already said, raised this issue about notice, and I was also kind of struck by Commissioner O'Donnell's questioning about the, definitions. Is this urgent? It doesn't strike me that the time we spend now is all that great at AMs. And I know that it seems like often People's Council files and has questions. Recently, we dealt with one of these supplemental type projects, waiver request projects. And I know staff had raised concerns that they weren't getting the information from the utility about the project and whether or not it was, cost, if they had considered less costly alternatives. So I just question whether we're kind of rushing this right now, if we ought to get more input. Again, I don't know if we have someone from People's Council even paying attention to this hearing today, but they might have something to say about it. So unless like, Mr. Trout or staff have, concerns about the urgency of taking this on, I personally am not that interested in taking this up in this proceeding. Thank you, Mr. Chairman.
Thank you. Any other commissioners?
Just a thought, Mr. Chairman. Mr. Trout, we talked about similar structures mostly, but materials or equipment. But the big one for me, and it's the painful experience of the settlement agreement finally reached in the Maryland portion of the TransSource. The essence of that settlement hinged on, I believe, rerouting on existing structures and not going to greenfields. And that language, similar location, really is the one that gives me the most heartburn, because if you go to a greenfield location that's similar to the existing location and it's waived automatically, that's problematic. That's a big problem.
I have to tell you, Commissioner O'Donnell, when I read similar location in the context of doing maintenance, repairs, and like-kind replacements, I understood that sometimes you have to move a pole. When you take an old pole out and you put a new pole in, you have to move it a few feet. And you certainly wouldn't, so you're still not only within the existing right of way, but within the center line of the existing right of way. And there was no thought at all that this could encompass green fields.
I appreciate that. But not everybody's astute as Mr. Trout, and some may stretch the meaning of similar location in the future to allow them to do that without any notice or permission or anything. So
I understand.
Thank you.
Trout, despite my support, it doesn't appear that you'll have the support of the majority of the commission. What do you wish to do?
My recommendation to the commission would be to table this and refer it to a later separate rulemaking. where we could address the concerns that were raised by Commissioner O'Donnell and by staff. Staff's concern would be met. Commissioner Herman's query could be addressed. And, you know, so here I am, I'm one step beyond supporting another report. Here I am supporting another rulemaking. But that seems to be the best procedural path, because I would not want to force the commission to reject this idea, and nor would I want to try to get votes for something that the commissioners have evinced their discomfort with, and that staff can't support for process reasons. That makes me uncomfortable that staff can't support it. So
Okay.
for all those reasons, my recommendation would be to table this, not include it in the set of regulations that you would vote on at the end of this hearing, but rather refer it to a later separate rulemaking.
Okay, the petitioner has withdrawn his proposal prior to a vote. Mr. Trout, it's incumbent on you then to petition the commission for a rulemaking when you see the time is fit.
I was afraid you would say that, Mr. Chairman. Fair enough.
Thank you. Ms. Best has deleted the proposed language. We'll now turn to regulation.
Mr. Chairman, if I may.
I'm sorry.
I just wanted to let Commissioner Richard know that there are representatives from OPC. We are paying attention. We are here. I'm happy to be here. Thank you very much.
Thank you, Mr. O'Loughlin, on the record. We'll now turn to regulation number 11.
Thank you, Mr. Chairman. So regulation number 11 refers to the availability of applications and related materials, specifically at the commission and the offices and website. This is a new section, but the spirit of this provision is currently captured in part of the previous regulation for completeness and availability. So some of this language is not new. It's just housed in a new section. Staff is not aware of any objections to this specific provision, so I'll pause there and see if there are any comments to that.
Mr. Chen, on the top line, is there a requirement that citizens be able to come to our offices for public inspection, or can we just have it available on the website?
So, Mr. Chairman, it's taken from the previous language of the COMAR. I think just in practice, the commission has always made its filings and documents available for anyone who wants to come to the commission offices under these extenuating circumstances. Today, it seems that it makes more sense to make them available.
Mr. Chen, we're losing your audio.
I'm sorry, I was about to say that most of the documents are in fact available on the website with exception to.
We're still having problems. But I think I heard what you said. I don't feel strongly, but I don't see the need for people to come to the commission to view documents. Do commissioners or any parties have concerns with Regulation 11?
I would like to, Wendy Kearney, on behalf of Frederick County, for the record. My concerns with the language is that every part of the record should be available for inspection. And by enumerating specific items, by implication, you could be excluding other items. I think this circles back to my comments yesterday regarding transcripts, etc. I understand the commission's position on that, which would, I hope, be subject to review next time you renew the contract with the recording company, the stenographer. But virtually anything put in the record, everything is public information and should be available. I believe the fallback language back in the day was you had a person under the Public Information Act has the right to go to an office and ask to look at documents. That's kind of the old school way of handling Public Information Act requests before the days of internet and scanning files and emailing them. The traditional way was, if you want information, here's the box, look through it, mark what you want copied, and then we'll make copies and go on your way. So I think that if anything, the reference to being available at the offices is kind of a traditional methodology, which has most times now proceeds with a request and a search and electronic transfer, but not always. The volume of materials, in certain occasions we do through the county, we will say, okay, these are old records, for example, that aren't electronic. Come look at this box and mark what you want. So just trying to provide some background there.
Thank you, Ms. Carney. No, I understand that. I fear that in a post-COVID world, now that we're not receiving any paper copies, to the extent somebody comes to the commission, we may just give them a laptop and a table to go to our website and find the documentation. In addition to your concern yesterday from transcripts, there are some limited waivers available to elected officials, non-party individuals, and local governments to request a waiver. So it may not be free, it may be a discounted rate for availability to the transcript, but that's an option that local officials and governments can explore if and when they need access to a transcript. Other concerns? Okay, hearing no others or no proposals by commissioners to modify this regulation, we are now done with chapter number 1. We'll move to remaining issues in chapter number 2, beginning with regulation 1A1. It'll take Ms. Best a moment to bring up the new document. Mr. Chen.
Thank you, Mr. Chairman. I thought I would actually take the minor revisions under 1A as well as the revisions under regulation 2 together.
Chairman, this is Chris. I think Mr. Chen needs to do something about his audio. It's very, very difficult to hear him.
Yeah, Mr. Chen, your audio may not be fully connected or maybe turned down very low. It sounds like a mere whisper coming from you.
I will try to call in.
Okay, call-in number?
If you just give me a moment, please.
Well, while Mr. Chen is dialing back in, the entirety of the revision is before us right now, which includes electronically signed items. Do any stakeholders or commissioners have concerns with the acceptance of an electronic signature? Hearing none, we'll move to 2A, B, and C. So 2A relates to streamlining the number of paper copies. The commission has gone from 17 copies down to 12 and currently at 0. These edits reflect that change in 2A. And in 2B, this is with respect to copies that will be sent to external entities. And if we scroll down a little further in B, we'll see who they are, including members of the General Assembly, county and municipal governments, planning commissions, and there we go, Department of the Environment, or just a clarification edit in 7 there, as well as a clarification edit in 9.
Mr. Chairman, hi. I apologize. Can you hear me?
Much better. Much better. Thank you. Mr.
Okay.
Chen, we moved along without you. So Ms. Best is scrolling her way down to the next regulation, which were relatively self-explanatory. Includes additions for both the EPA and now the Department of Defense.
Okay, yes, excellent. What I was starting to say is that I thought it'd be most time efficient to address both the NIT revisions as well as the copy number revisions under regulations 01 and 02 together, because they're largely non-substantive and articulate really a shift away from the paper filings to electronic filings and electronic service. So they, as you said, that they are mostly self-explanatory. So really, I'll just stand by for questions.
Okay, Ms. Best, is there anything else below D that we? Nope, it doesn't look like it. Okay, and any concerns or questions from commissioners or stakeholders?
Just a quick question, Mr. Chairman. Did our assistant executive secretary have a chance to weigh in on this? I know Mr. Collins always explained why it was the 17 three-hole punch copies provision was there. And I think we're all generally happy with the electronic filings and going away from paper, notwithstanding Commissioner Herman and my affinity for paper. But I'm wondering if anybody on the management staff had weighed in on these changes.
Well, we have not posed that to the executive secretary, but we certainly can over the course of the break at the first opportunity to do so.
Okay, I'm hoping they don't have any concerns. I don't have any concerns.
Okay, if we could continue scrolling down.
Mr. Chairman, just a question for number C, letter C.
Go back up.
We just went past it. Yeah, so I know this isn't new language, so this is, I'm assuming it's the existing language. So I guess I would ask the staff, have we had any issues with applicants being able to determine other state or local agencies that may be affected? I mean, are they making that choice on their own, or are we telling them, or maybe they're just entering their own appearance?
From the standpoint of, from their perspective standpoint, no, we don't know the answer to that. And, but I don't know the extent of any previous examples of concerns with receiving a paper copy versus an electronic copy.
All right, well, it's existing language, so I'm not going to try and change it now. I just was curious. Thank you, Mr. Chairman. Thank you, Mr. Chair.
Thank you. Okay, where do we go from here? I believe this was the end of this regulation. What's the next regulation, Mr. Chen?
So if we're ready to move on from this chapter, that's all for chapter 2. And I believe that we can move on to chapter 3. Chapter 3 goes specifically to the information applicable and required for generating stations, to be distinguished from chapter 4, which relates to transmission lines. It's outside the scope of this rulemaking. But chapter 3, staff's proposals are a lot more comprehensive, as you'll notice, and compared to the original COMAR language. There's a lot more red line here. But I figured that there's a way that we can organize this, and I'll just proceed regulation by regulation. And I don't, unless the commission has any questions and wants to examine specific items and subsections of each regulation, we can do that. But I thought that I'll just give an overview of each large regulation. So starting with regulation number 1, currently under COMAR, the applicant is required to provide a general description of the proposed generating station, which you see here, and it's captured in sections C through I believe it's I, with the exception of a new addition, letter E, pertaining to the life expectancy of the facility. But as Ms. Bess is scrolling this, you'll see that the main addition here is the inclusion of a high-resolution concept plan. And this was at the request of some of our stakeholder, county stakeholders, and staff tried to incorporate their input to see what information they typically need and want to see in a concept plan for the purposes of that pre-application consultation requirement from Chapter 1. And except for the coalition, staff is not aware of any other objections to this listing under the requirements for a concept plan. The coalition did, in its comments, disagree with the inclusion of item number 6. I believe it's number 6. I'm sorry, if we could go, yes, right there. The preliminary information as required under the Forest Conservation Act, where the coalition would advocate to delete this requirement. There may be other participants here today who would object to removing this. So with that, I will yield for questions, or I don't know if the coalition would like time to address their concern with number 6 specifically.
I can speak to item number 6, Mr. Chairman. We spoke with counsel for PPRP about this issue last night. And actually, at this point, we're willing to withdraw our objection to the language in section 6. But I do want to point out that there's later language that we're going to discuss further down the regulations in 2079-03-03B1 with respect to the FCA. And our support of this language in 6 here is contingent on the adoption of that later language. So assuming, we move forward with what staff's proposed, we're actually comfortable with it, and hopefully that resolves this issue.
Mr. Chairman, Chris Drummond, again, representing Queen Anne's County and Dorchester County. Perhaps we need to address what Mr. Buell just referred to as his contingent withdrawal of the objection to number 6 by referring to B1C, which from the county's perspective is very problematic language. We are not in support of the language of B1C in as much as it refers to voluntary compliance with the Forest Conservation Act and or the local forest conservation ordinance.
Mr. Chairman, may I suggest that we table section 6 and for the time being, wait to address section 6 at the appropriate time when we get to the natural resources section. That seems to be better for than just kind of flipping back and forth. So with the exception of section 6, are there any questions from the commission for everything else under regulation 1? And this goes now to expanding on the definition, or I'm sorry, the description, required description for a generating station.
Hearing no objections.
Okay.
And for the parties, I cannot see if you're raising, if you're using the raise hand feature because of the screen format now. So to the extent that stakeholders need to jump in, please just turn on your microphone at the opportune moment. Thank you.
So if you thought that regulation 1 was descriptive, then moving on into regulation 2 and regulation 3 and 4, when we take them in turn, are going to get into a lot of technical detail. Regulation 2 begins by setting out the environmental information that's required in an environmental review document. And that's, as I mentioned yesterday, is usually is accompanying a CPCN application for a generating station. And by and large, this is that central document that you would find all this information today for environmental impacts, for natural resources, economic impacts, things like that. Just before today, just wasn't spelled out in detail. But that is what is proposed. That's what staff's proposed. Currently, every CPCN application is to construct a generating station includes this information, at least ERD. However, but in practice, what experience has shown, and Ms. McLemore can add or correct me, but my understanding from their experience is that there's often a back and forth that then follows during the review process, data requests, and during discovery, where PPRP sometimes has to chase after information. And so by front loading the expectation and spelling it out in detail up front, parties know exactly what type of information, environmental information that they need to include. And as this commission knows, PPRP and the reviewing state agencies use this information and rely on it as part of their independent project assessment to produce their own PAR document, project assessment report, that comes in every CPCN matter. So,
Mr. Chen, I got a general question.
Yes,
This detailed information, how does it relate to the previously discussed checklist of what needs to come with an application?
all of this information has to be included as part of the checklist. So the checklist,
I'm sorry, go ahead.
The checklist incorporates by reference everything you see in COMAR regulation, staff's proposed COMAR regulation 1, 2, 3, and 4.
Okay,
so
fair enough.
all of these
Thank you.
requirements-
That's helpful for me. It gives me some level of comfort.
Yes, thank you, Commissioner. And I apologize if yesterday I wasn't able, I did not make that clear. So I think at this time, PPRP is ready to answer any technical questions. I'll say if the commission has any concerns or wants to explore any one of these requirements in further detail, we can certainly do that. Now, I will mention that the coalition has added or does recommend adding additional provisions, which Mr. Buchelmans can speak to, and I believe some of this is tied to legislative activity. So let me just say that they're recommending their recommendations would add the requirement that an applicant must include a discussion of the proposed project's ability to meet the state RPS requirements, as well as the state's greenhouse gas reduction requirements under the Greenhouse Gas Reduction Act. So I think I'll just yield for a moment to Mr. Bugelmans. He has the coalition does have an update as to the relevance to legislative activity, I believe.
And let's scroll down to the very end where we can actually see that language. And I know Mr. Drummond caught a typo along the way regarding freshwater resources. We'll get back to that in a second. But if we go to the bottom, all the way, number 6, I think, 5 and 6. There we go. I believe, Mr. Chen, that's what you're referring to. Mr. Bugelmans.
Thank you, Mr. Chairman. So as you can see here, USIC has proposed additional language that require two things. A discussion of the impact of a proposed project on the state's ability to satisfy the RPS, and then also the impact of a proposed project on the Greenhouse Gas Reduction Act requirements set forth in the environment article. It's impossible, I think, in 2021 to separate the consideration of renewable energy benefits and climate change impacts from whether a power plant should be built in the state. Obviously, all the other environmental and local siting factors are very important to the Commission's review, but clearly this is an extremely relevant piece of information for the Commission's analysis. Most recently, in case number 9439, the Commission found that the RPS and the impacts of a project and the ability to satisfy the RPS are something that should be included within the Commission's analysis. So it is something that fairly recently the Commission has opined on. Mr. Chen referred to legislation that's been advancing this session. It's House Bill 298, which my understanding is it's passed out of the House and then passed the Senate yesterday. That bill would specifically add requirements for the Commission to consider climate change impacts under its due consideration analysis. The bill is quite specific in terms of what should be considered. And I was actually just made aware of this. So it's something where maybe staff would want to look at if the Commission wants to incorporate this, what that says and try to make it line up with what's in there. But even without that legislation, I think this is something that's relevant. It's important to the Commission's review. The Commission has said it's something that should be considered. So we've proposed this language here in 6 before you. I would also like to say, I think there may be somebody from Sierra Club on who would like to speak on this issue, although I'm not sure if he's able to join.
Yeah, good afternoon at this point. David, thank you. And Mr. Chairman and other commissioners, thank you for the quick opportunity to speak. This is David Smetic with the Sierra Club. I'll be relatively brief because Mr. Bugelmans largely said everything that I would have in this space. We do think that this is a critical consideration for the Commission and for the CPCN process. So with the language that's proposed in front of you now, as well as with the potential modifications that would be needed with the legislation that's advancing through both chambers of the General Assembly, we think this is critically important and that the consideration of climate change impacts and the ability to meet the state's RPS and contribute to those goals is really fundamentally important as we're moving into 2021 at this stage. So we would encourage you all to adopt some language to have that incorporated into this portion of the discussion. And it's probably the only time I'm going to speak up today, but I did want to have that brought forward to you all and appreciate the chance. Happy to talk about it, though.
Commissioner O'Donnell.
Mr. Smetic, thank you, Mr. Chairman. Let me take an opportunity to ask. I think it's important as well for the Commission to consider these important public policies in our decision-making processes. So there we have no disagreement at all. I just want to get your view of what impact this new language may have on somebody an applicant who may be attempting to site and build out a natural gas fired unit somewhere in the state.
Absolutely. Thank you, Commissioner. So I think that this provides the opportunity for the public, you all as commissioners and anybody else involved in the process to take a hard look at what the role that a new proposed gas-fired unit would or full station would have on the state's ability to meet those climate change goals. It does not preclude the commission or whoever from approving the project. It's just to have this as a primary part of discussion and consideration as it's looking to it. So I don't view this as stopping any proposals in the fossil fuel category. I think it's just it adds to the discussion that those need to be considered through the conversation.
Thank you for that. I appreciate that very much, and I just kind of wanted to get on the record that this new language wouldn't be dispositive of the ability of the commission to make a public interest decision overall, considering a lot of different factors. So thank you for that. I appreciate it.
Thank you.
If I may speak, Wendy Kearney on behalf of Frederick County, Maryland. I have serious concerns with, first of all, seeing this language for the first time today, and also concerns because the provisions of the state law govern what is to be considered in reviewing a CPCN application, and subsection A, 6A, is not part of 7207. So this is this proposal runs contrary to the state law and would not be within the commission's authority to graft a new requirement, so to speak, on the review of a CPCN application.
Kearney, can you elaborate? How does this proposal run contrary to state law? I believe that this proposal was contained in USEC's comments that were previously filed. If I'm not correct, Mr. Biegelmans could correct me.
It was, Your Honor. This was contained both in our initial proposed regulations and our supplemental comments. So it has been put before stakeholders in this rulemaking.
Well,
I would also note that I do not think that the specific items enumerated in the statute are exclusive. And the commission's job in a CPCN proceeding is to determine what is in the public interest, and any information that affects that can be sought and required in that proceeding. The items enumerated in the statute should be viewed as being a floor and not a ceiling.
And I can echo that. I mean, there's Court of Appeals precedent that basically says what Mr. Spivak just said. You know, it's basically the due consideration standard is very flexible, and it really is a public interest test. That's what the courts have said. I think as a corollary, if what Ms. Kearney has said is legally true, then a lot of the other elements that are in COMAR today and that we're also discussing wouldn't be able to be considered by the commission. So I think the CPCN process and the commission's authority is very broad, and they can consider, I think, almost anything to the extent they find it irrelevant. And, you know, I think this is something that's clearly relevant. I think you can't separate it from whether to approve a generating station in this, you know, in 2021.
As the commission can see, you have very strong differences of opinion between attorneys on what can and cannot be included in regulations that are being promulgated pursuant to the state law statutory authority. Again, the state law governs what can be reviewed and what is to be considered very clearly, black and white. They call it black letter law. 7207 specifies the items, and this appears to be an attempt to graft additional criteria, which is, in my professional opinion, beyond the ability and the scope of the authority of the commission.
Other concerns from stakeholders with respect to this proposal, number 6?
Sandra McLemore on behalf of PPRP. I would echo staff and Mr. Bugelman's position on that it is a floor and not a ceiling, and that those requirements set forth in 7207 are general groupings of things that the commission has to consider. It does not exclude other things that are important and relevant to the public interest.
Do commissioners have any concerns or questions on the proposal? Hearing no objections, Mr. Bugelmans, I know you have one additional proposal a little further up under 3D we should take a look at.
I do, Mr. Chairman. This is a much simpler change. If Ms. Best could scroll up to it, I could talk about it here. I think it's in 3.
There we go.
So our proposal here is this subsection of COMAR is about water quality and water issues generally. Our proposal is to specify that when affected streams and wetlands are identified, that a complete application should include an assessment of positive or negative impacts the project will have on water quality. It's something that projects are already, I think, incorporating into their ERDs, but it's kind of a technical clarification to make sure that's clear in terms of what should be provided.
Any questions or concerns with this proposal? Hearing none. Mr. Drummond. Oh, Mr. Sadinsky.
Yeah, sorry. Yeah, Bob Sinski, Maryland DNR Power Plant Research Program Acting Director. No, we would support this change in language. Thank you very much.
Thank you, sir.
Mr. Chairman, staff has no objection.
Thank you. We'll look to item B right above. Mr. Drummond, it looks like you caught a typo. Is there anything beyond that you wish to propose?
Chairman, no, not other than the typo I caught, and I guess we're going to head back to the forest conservation.
Well,
in a bit.
Okay. Thank you.
That's just corrected item B.
Actually, Mr. Chairman, staff consulted with PPRP, and the one-word change should be on freshwater resources.
So, Mr. Drummond, we went from to on. Mr. Drummond, we can't hear you.
I see. Oh, I'm sorry. That makes better sense than what was there before.
Okay. All right. Very good. Mr. Chen, do we have anything else left in this regulation?
Not in Regulation 2, Mr. Chairman. We are prepared to move to Regulation 3.
Okay, so we're done with the environmental regulation. We're moving to the natural resources information regulation under 3.
Staff's proposed Regulation 3 houses the natural resources information that would then be included with the applicant's ERD. And this focuses on the applicant addressing impacts on the state's natural resources, of course. And those resources include, among other things, impacts on forests, impacts to rare, threatened, and endangered species of animals, impacts to critical areas, which include the additional requirements for solar photovoltaic generating stations located in the resource conservation area, noise impacts, as well as subsurface disturbances. I have one punctuation correction for Regulation 3B8. There should be a period when we get to that. A period after, if applicable. And as you've teed up, as the parties have teed up, there is the contention regarding the Forest Conservation Act, local forest conservation ordinances requirements under 3B1. Okay, and in particular, little c is where we're gonna focus our discussion here. So you've heard from the coalition that they support staff's language here, but you've also heard from Queen Anne's County, and there are other similar aligned stakeholders who disagree with including the word voluntary in front of compliance, and that voluntary should be stricken insofar as they believe that compliance with the Forest Conservation Act is mandated. So I will yield the rest of my time to the parties who wish to, start the discussion.
Thanks, Mr. Chan. This is Chris Drummond again. I do not argue that compliance with the local forest conservation ordinances, to the extent that they might be more restrictive than the State Forest Conservation Act, is required. I think the Public Service Commission has made clear in a couple of cases, the STAR and IBIS projects, that to the extent that local forest conservation ordinances may be more restrictive of the Forest Conservation Act, those provisions are preempted. However, Public Service Commission has also made clear under the due consideration requirement that compliance with local forest conservation ordinances is extraordinarily important and will be taken very seriously by the Commission when it applies the due consideration standard. And in my comments to Mr. Johnston on January 29, 2021, I referred to the order number 87-835, which emanates from both the Blue Star and IBIS cases, where the Public Service Commission made it very clear that, quote, it should only be in a very rare instance in which the exercise of due consideration results in the complete preemption of all afforestation and reforestation requirements. I'm concerned that B1C, Roman number 1, undermines what the Public Service Commission has announced as its intention and policy to take both the Forest Conservation Act and any forest conservation ordinances, even if they're more restrictive, very, very seriously. And I don't have alternative language for Roman number little 1. It just concerns me that the word voluntary is a message to the applicants that's inconsistent with how seriously the Public Service Commission has indicated it takes afforestation or reforestation.
I can respond, Mr. Chairman, to Mr. Drummond's comments. I generally agree with Mr. Drummond's summary of commission precedent. It's clear the commission takes forest conservation ordinance and act issues very seriously. And as a result, I think what you've seen is almost every project, unless a county agrees that there should be some kind of deviation from requirements, has complied with the county's ordinance, which is, under the way the Forest Conservation Act works, either that's going to be at the level set by the state level FCA or something more stringent. So that's the reality on the ground. The language in staff's proposal is based off of language that USAC proposed in its initial comments. And what it's supposed to do is allow for the different situations under the Natural Resources article, recognizing that even though the commission has said that Forest Conservation Act issues are very important, exemptions are still possible. So that's what those 3 Romanettes are supposed to do under C, is account for those different scenarios. If Mr. Drummond's concerned about the word voluntary, USAC would be completely fine and would agree with striking that word. The intent wasn't to minimize the importance of these issues. Again, it was trying to incorporate the different scenarios that may be possible under the FCA, which I can get into if the commission would like an explanation, but we would be fine deleting voluntary from Romanet 1.
Thank you, Mr. Begelmans. I think there was some sensitivity, intentional or not, that the term voluntary may give a developer license to ignore or minimize compliance. Effectively checking that off the box, we don't necessarily need to comply. But as you can see in C, right above it, the applicant's proposal to address any FCA ordinances, they'll have to show that they've taken some steps, and the commission, in turn, under law, has to provide due consideration to the ordinances and rules and regulations of the county. So I think that that offer will be accepted by Mr. Drummond, as well as
Chairman. Sorry.
Mr. Chairman, I'm not going to look a gift horse in the mouth.
Commissioner O'Donnell.
I was just going to suggest, might it be helpful in lieu of voluntary, just put the word, make the beginning of little I, efforts to comply with. So we see including efforts to comply with the applicable forest conservation ordinance, including the submission of a completed conservation worksheet for the county or municipal corporations. That way we could evaluate with that language the applicability or the preemptive nature of the State Forest Conservation Act, and which would prevail here.
Any objections to Commissioner O'Donnell's proposal to include?
No, I think that's fine. Chris Drummond, I think that's fine.
Yeah, I would agree with that. I wonder if we should also use that same language back up in 6 and just strike the word required and preliminary information in efforts to comply with the Forest Conservation Act. Just again, since required may be a little too strong in that point, and that way I think that would make the 2 sections I think more in balance.
Mr. Chairman, staff has no objection to that.
PRP also supports that.
I believe Ms. Best was trying to find where Commissioner Richard was citing to in 6. I'm not sure. Did we find it? Are we back at 6?
Yes,
Okay.
she's there. Preliminary information in effort to comply with.
I thought we could just use similar language there, since again, required may not be quite the accurate word to use.
Well,
Since,
there is
accepted.
there is a hard requirement to comply with the Forest Conservation Act. One was local, and this is state. So there's a distinction. There's
Right.
an absolute requirement for adherence to the Forest Conservation Act.
Chairman, if possible, can we come back to that maybe after the break to verify that that won't have any implications? I'm not quite certain it won't.
Let's take a look at this. Commissioner O'Donnell's right. This is the state law. We're referring to the FCA as opposed to the ordinance at the county level below. So we'll highlight this and we'll come back.
Okay.
Thank you.
And it looks like we'll probably be breaking for lunch soon. I think we'll need a lunch break. We're moving quickly, but not that quickly.
Chairman, if Mr. Chen could put on the screen the language that was added in light of the changes at the Critical Area Commission about solar in the RCA? Oh, here it is. No.
Mr. Drummond, do you know what regulation number?
That's
Chapter-
B5. Okay. For someone in local government who has engaged with the Critical Area Commission since 1988 and fought with them over what can and cannot happen in the resource conservation area, it's stunning that the commission has decided to allow utility scale solar in the RCA, but that's what they decided to do. To my knowledge, the regulations that were recently promulgated by the Critical Area Commission do in fact refer to what is in 5A as calculations of any required reservation of resource conservation area density rights. That language does appear in the regulation. There is nothing in the regulations of which I'm familiar, nor are there any local programs that explain how those calculations are supposed to be done. I don't think that's the Public Service Commission's problem, but we now propose a rule for which I'm unaware there's any methodology to comply with.
If I may speak to that, yeah, Bob Sinski, PPRP. So we have worked on language with the critical areas, and this is really, they have looked at this language and have okayed it. This does take effect. I mean, it went into the Maryland Register on March 8th of this year. It does take effect April 1st of this year also. Its purpose is to provide basically development standards for projects in the critical area and also in the resource conservation area.
Okay, so those regulations are making their way through the process now.
But I've looked at the regulations and I don't see the methodology for calculating required reservation of resource conservation area density rights. Maybe I missed it. Aside, we're being stunned that the Critical Area Commission will allow this in the RCA.
The calculation methodology is not contained within these regulations. I think the question is, are they contained in the CCA regulations? Mr. Stadinsky, do you know?
I would assume they are, but I can certainly ask on the break.
Okay, thank you.
I would also point out, it says any required, so it in the event that it isn't currently, that would allow for them not to have to include it unless they are included. I think that's kind of the reason for that wording as well. But we can touch base, as Mr. Stadinsky said, with the critical area.
Do we have any remaining contested issues in the natural resources information section? So this is regulation 3.
I'm sorry, Mr. Chairman. Could you please repeat that?
Anything else in regulation 3 we need to discuss, or are we finished? Subject to these loose ends.
Right. Well, subject to those, I don't believe staff has anything else that that's outstanding with regulation 3.
Okay. What we'll do is we'll take a lunch break at this point. When we return, we'll come back and address regulation 4, which is the socioeconomic information. And after that, we'll go back to the description of the generating station and address the item that we put a pin in at the beginning. So we will we'll now take a lunch recess. I've just been informed, Commissioner O'Donnell, that the Office of the Executive Secretary has reviewed this rulemaking and has no concerns with the requirements. So
Thank you, Mr. Chairman. I feel greatly relieved.
we are in recess for lunch until 1:30 p.m. Have a good lunch.
Chairman, I would also like to let you know that Mr. Towson will be representing PPRP at lunch, after the lunch.
Thank you. I was aware. Have a good day, Ms. McElmore.
Okay, thank you. Bye.
We'll go back on the record in approximately 1 minute. We are back on the record in rulemaking number 72. When we last left off, we were about to proceed with regulation number 4 regarding socioeconomic effects. Mr. Chen.
Thank you, Mr. Chairman, and good afternoon, commissioners. So I'd like to say that we're coming down the home stretch here. Comar 29/2079/0304 is the last truly substantive listing of information that would be required to be included by an applicant with every application for CPCN to construct a generating station. And Regulation 4 specifically goes to the socioeconomic information that the state agencies need. So currently under Comar 2079/0301, this is the current version today, the applicant's general description must include a description of the impact of the project on the economics of the state. But if you look at the ERD, if you look at the commission's orders on CPCNs, the analysis for the socioeconomic impacts that kind of flows out of the Public Utilities Article 7-207E factors, it's actually quite more detailed and comprehensive than just a simple description of the impact on the economics of the state. So the information is this staff's proposal is intended to include information that typically is discussed, such as unavoidable socioeconomic effects due to construction, as well as the operation of the facility and any recommended mitigation of those effects, any impacts to historic or archaeologically significant resources of the state, impacts to agricultural resources, and this speaks to the prime farmland topic that Commissioner Herman flagged related to her inquiry. Impacts to public safety, transportation, including traffic, proposals for visual impacts for projects, particularly this is commonly addressed for solar generation facilities, vegetation management, the effects on the local economy, which also are key discussion points, and glare analysis is something that we appreciate that the coalition for recommending this particular inclusion is something that they do, and as far as their projects, and it makes sense for solar applications. The regulation also incorporates by reference, where it is applicable, any required environmental justice information that's listed in the next regulation, which is not really part of staff's proposal, and that's 2079/0305, which was previously established through RM69. As far as stakeholder concerns, staff is aware that specifically an affirmative statement with respect to, well, let me just take a step back and say, I'm talking about provision 4B, 6D. So I'll pause for a minute for it to come up on the screen. And I believe this is really the only stakeholder concern that was flagged.
And who flagged it?
This is Davidson Area Civic Association. I don't know if they are here today with us.
Is a representative present? Okay, Mr. Chen.
Okay. So here, as you'll see, it would require an affirmative statement whether the applicant intends to apply for a pollinator-friendly solar designation, or if the applicant intends to incorporate agrovoltaics, if I pronounced that correctly. The concern raised by the Davidson Area Civic Association was that the applicant really only is required to provide the affirmative statement and nothing more. And the applicant could simply provide a negative response to these terms. And so the association would recommend that that in addition, if the applicant is responding in the affirmative, to also provide a description of the applicant's plans if they weren't already included with the application. And then if the applicant is going to respond in a negative, then some explanation as to justify a negative response. So staff does not necessarily object to this recommendation by the Civic Association, but it may be worthwhile to hear from PPRP and the coalition as to whether, number one, the extent to which the applicants are providing this information already today, and number two, if they're not, then the practicality of being required to do so. So with that, I'll yield.
Yielding to PPRP.
Yeah, good afternoon, Mr. Chairman. Bob Sinski, PPRP Acting Director. So as far as applying for the pollinator-friendly solar designations, usually that is included in the ERD. If not, we generally ask a discovery question on that. And generally, I mean, they always want to participate, especially in recent cases. I would caution, though, as far as adding any details, because remember, this is still in the process of being reviewed by us. So to say what they're going to do with pollinator habitat might be too specific at this time.
Thank you for your input, Mr. Sadinsky. Any other stakeholder concerns? I believe Mr. Chen said no. Any thoughts or concerns or comments from commissioners? I do tend to.
Chairman, this is Chris Drummond. I should point out that in Queen Anne's County and in a burgeoning number of counties, landscaping standards include a pollinator element. So the local landscaping standards are likely to cover this in any event.
Thank you, Mr. Drummond. That's helpful as well. Based on what I've heard from staff's proposal and Mr. Drummond and Mr. Sadinsky, I am comfortable with the proposed regulations as drafted. Commissioners, any concerns? Hearing none. Mr. Chen. Mr. Chen.
I'm sorry, I forgot to mute my mic. So, commissioners, this pretty much wraps up the substantive list of all the technical information that would come in with a CPCN application, either in the ERD document or in the detailed conceptual plan. So I believe that just one thing before we get to the actual wordsmithing language, before we broke for lunch, there is one other attachment that staff included with its petition for the rulemaking. That's the application checklist public document. So this document actually, all it is, it just serves as a public document that would be hosted on the commission's website, again, for the benefit of general reference download, if you will, for developers, for anyone who would like to conveniently look at all the requirements for the checklist in one place without having to go directly to the COMAR, because everything that you see on the checklist, and that's attachment D in the December filing, that's mirrored in by the COMAR regulations, chapters 1 through 3. Now they'll be adjusted and updated in accordance with the commission's decision today. So there's not much more that I would need to say, other than the staff is not asking the commission to approve or codify the public document, because as I said, the items are already, that's taken care of in the rulemaking. So if there are questions, or if the commission doesn't feel that having a public checklist document is necessary, that would also be good to know.
Thank you. I did find the checklist to be helpful. If changes are to be made or revised, can the document be revised by staff at any time without prior notice?
If there are substantive changes to the public version of the checklist, I believe the answer is no, because you know, the content of that checklist flows out of the regulations. So if there are any changes to the regulations or checklist items, they would need to be done through the regulations and through a rulemaking. And I think that there are also concerns raised through the agency that approves the adoption of state regulations also has flagged for us that the proper path would be through the rulemaking if we needed to make any substantive changes later on in the actual public document.
So in order to make any changes to this document on our website, we'd have to initiate a new rulemaking. Is that right?
If they relate to the requirements, yes.
That's all I had.
I have a question. Is there anything elastic in here? Any kind of elastic provision? Anything that talks about other information that may be applicable, or is this it? This is all you got to put in, and that's it, done, and don't ask for anything else?
As far as attachment D, the public checklist document?
Yes.
Okay. There is no elastic component as you described, Commissioner.
Yeah. I guess I'm still uncomfortable with being so prescriptive that we can't use creative thought or independent thought when we know something's unique or different. We can later in the actual merit proceeding, but not at this stage. And I just think that that's unfortunate.
Commissioner, if I can ask this follow-up question / thought, if the checklist serves the purpose of a topical review, a superficial review of what's in the application file package, and then in order for the person who receives that and then hands it off over to the state agencies for review in terms of the actual content and, you know, all the details and analysis, if you will, of everything about this project. If it's really just a handoff, then later on, if the reviewing parties find that, you know, there's an issue, there's a concern, and they need to address this with the applicant, they do that, or they attempt to do that. And if there's any kind of pushback, then presumably they would take that to the decision maker to break that logjam. Is that scenario, does that address your concern?
Possibly, but if it's not on the checklist, if it's information that's not on the checklist in that scenario you described, I think we've set up a regimen that says I don't have to submit that for the application. And that could be the response from the applicant. It's not required.
That was my concern to the coalition and to Mr. Bugelman's yesterday, and his response was that was never our intent, and I do get that, but even so, you know, the checklist is really that passing of the document from the person who receives the application to the team that's going to review it. That's one thing. And also, I don't think that the checklist, let me just say from staff's standpoint, when we construct this and this this framework, the commission is always able to the checklist doesn't say the commission can't request information later on, and the commission can certainly do that. And my read or take of that situation is if, let's say, you have a reluctant party who's not willing to provide that piece of information and would, you know, try to stand by the argument, well, this wasn't on the checklist, so I don't have to provide it. Well, number one, we've already eliminated the language that the commission can't deny the application for failure to include that piece of information. So that provision's already gone. I'm sorry, I can't hear you, Commissioner.
We didn't eliminate the provision that says a determination of incomplete application can be made if everything that's on the checklist is there and we want more information to determine completeness. We're not entitled to that information anymore. That provision was not eliminated. It was put in a 3-2 vote.
The nuance is not so much we're not entitled to it. I wouldn't go that far. I think what it is that we wouldn't be able to stop that package from moving from the receiver to the review team. So when it gets into the hands of a review team, and they say there's something that's missing that's important for determination of public interest, my view, and I will defer to staff to correct me if they believe differently, but my view is that the commission is still fully able to deny a CPC an application on the merits if it says, okay, well, you are missing a critical document that addresses one of the due consideration factors, and upon that finding, we determine it's not in the public interest to issue
But
this.
you're talking around me here. Mr. Chen, with all due respect, we adopted a regulation, at least tentatively, not finally, that says that if it's not on the checklist, the completeness determination cannot be denied. You cannot be determined to be incomplete. If it's not on the checklist, it's complete by definition.
That is true.
So and you keep saying, well, it can be found out later, but that's in the merit phase. That's where you get to the public interest determination and at the end of the process.
Yes, I don't disagree with what you just said.
So I think we're talking maybe a little bit past each other. My concern is not in our ability to discover in the merit section. It's not. But I think we're limiting ourselves on the ability to get information in the completeness determination section. I just really think we are. And I understand the checklist helps the developers, and I want to help the developers. I want to increase their chances of completeness, a successful completeness determination. I think the checklist does that. It serves that purpose, and therefore I see the utility and merit in that. But I think it's just way too limited because of the clause that we adopted.
Noted, Commissioner. Thank you.
Can I take you back to a question I wanted to ask? It was in the socioeconomic section 4 of the detailed technical requirements. You had mentioned something about some language being added on environmental justice. I mean, and I'd like to explore that a little bit, if I might.
Certainly. Let me just pull that up on my own screen. Yes, I'm ready, Commissioner.
Can you put the language up there that was added so I can see it? Because we didn't really hone in on it.
Ms. Best, can you bring up Regulation 4? Okay, we have the section. Commissioner O'Donnell, is this the part of 4?
So I guess it's C, where applicable, the application shall address environmental justice information in accordance with Tomar 2079-0305. And what does that say? What is that reference?
So it recognizes that there are some CPCN applications that will come in that would trigger the requirement to run one of these EJ screen reports, because it's a qualifying generating station of 70 fossil fuel generating station for 70 megawatts or greater.
So utility scale solar, 200 megawatt solar plant wouldn't have to comply with that.
It would not be subject, correct, to Regulation 05 listed right below this provision.
That may be in the black letter of the law agreements we made under the MOU, under the Title VI concerns that we and other agencies had to deal with, but I don't think it meets the spirit of that, because communities of interest may be impacted by such a facility, and we'll find ourselves right back in the same Title VI, honeypot that we did before, because we didn't consider that for these large utility scale solar installations. And I just want to flag that. I find that problematic.
Commissioner, I know that I'm aware that staff is, staff council is looking into the questions that you've raised in recently concerning the application of Title VI requirements to other commission programs. So I'll defer to staff's research on that. But that particular provision and how it works, that it's probably warrants further discussion as how a solar facility and the community around the solar facility would be impacted, because as you know, the issues that could raise potential disparate impact concerns coming out of a solar facility are probably different from those from a fossil fuel generating station. So granted that in RM69, when these rules were proposed and adopted, they really were focused on those type of
I agree, and specifically the air quality concerns don't attend to a solar facility necessarily, but there may be other concerns. So air quality is not the only consideration to be taken into account in environmental justice initiatives, in my opinion. And I don't think that's the spirit of the law. In fact, I don't even think it's the letter of the federal law.
Thank you, Commissioner.
Mr. Chen, did we have other items in Regulation 1 or relating to the Forest Conservation Act that we needed to return to?
I believe we did, but that first would bring us to I want to find this.
Ms. Best, if we could go back up to 1.
Well, before we do that, Mr. Chairman, was there was there a definitive agreement on the voluntary compliance phrasing? I know that there was consensus to strike the word voluntary, but before that, did the commission land on just leaving it as compliance with the applicable forest conservation ordinance, or did the commission make a decision?
I thought we went with Commissioner O'Donnell's language.
Yeah, we resolved that already.
Okay, so it's efforts to comply?
Yes.
There, but the question became back up earlier in the regulation. Commissioner Richards suggested the same language be added to the Forest Conservation Act, which I thought might be problematic because that's not voluntary.
Okay.
Yeah, and he may be right. I think that's what you're going to look up. If it's necessary to harmonize, that would be great. But it was my understanding from the natural resources article is that generating stations were exempt from the Forest Conservation Act. If that's not correct for this section, then yeah, I would withdraw that. But I thought that was a blanket, exemption.
The generating stations, at least the tree clearing and cutting related to generating stations is one of the listed exemptions under the FCA, but that exemption directs the commission to the next section of that statute, which is the Forest Conservation Ordinance. So at the local level. And under the local level, paragraph F or section F of the Natural Resources Article 5-1603, that requires the commission to give due consideration as to the impact on forest loss and mitigation, afforestation, forestation for any given project.
I think I've heard it. I just thought there might be a harmonization issue, but I think at this point I haven't heard the industry USEC say anything about the required word, and I withdraw the suggestion.
Yes, Macklemore indicated, Commissioner Richard, before lunch that that PPRP was going to take a look at that specific language that suggested there relating to the Forest Conservation Act and see if there's any unintended consequences. So maybe Mr. Tolson has information for us.
Okay.
Mr. Tolson.
Okay, I'm sorry, I was on mute. Can you hear me now?
Yes.
Okay. Mr. Szydzinski may also want to weigh in on this, but we were fine with language to say that efforts to comply with the Forest Conservation Act, because this is dealing with the concept plan overall, that section. And so if Commissioner Richards' suggested language was fine with us, if you wanted to say efforts to comply with the Forest Conservation Act, the provisions that Mr. Chen just talked about in Natural Resources Article 5-1603F, it's just an awkwardly worded statute. It exempts these stations from strict compliance with the FCA, then turns right around and says that the commission has to give due consideration to those very same provisions. But what that basically does is says it's not binding on the commission. The commission can look at the record as a whole and then make a determination as to whether or not that's in the public interest. But if Commissioner Richard, I thought I just heard him say that he withdrew that recommendation to change, I think it was 2079-0301B6, then I think we're fine. And I would ask Mr. Szydzinski to pipe up if he disagrees.
I agree. Yep. Thank you very much.
Fine. Yeah, I like Commissioner O'Donnell's language, and I thought there might be a harmonization issue, but I'm fine if everyone's happy with required, I'm fine with it too. Thank you, Mr. Chairman.
Thank you. Commissioner Richards' proposal is withdrawn. Mr. Bugelmans, did you have additional items to address on anything in this rulemaking? I thought there was one item we needed to return to in this section.
I have no additional items, Your Honor. So I think that completes our list of proposals. Thank you.
Thank you. What about this item that Ms. Best is highlighting right now? Was this something we flagged earlier?
It is, and Mr. Szydzinski spoke with the Critical Areas Commission during the lunch break and would like to discuss adding an edit in to give a citation to the COMAR provision that tells you about those calculations.
Please.
Yeah, thank you. So, yeah, Bob Sinski, PPRP Acting Director. So we would just suggest adding the citation at the very end, and I can give you that citation if you'd like to type that in. So it's COMAR 27 01, 2701 1405, then the letter D is in dog. Yep, parentheses, yep. Parentheses around the D, yep. There's no objections. And I spoke to Critical Area and they fully support that.
Thank you for doing that on the break. So we should probably use the word pursuant to COMAR 27. Is that the proper phrasing in our regulations? Or in accordance with? I'm not sure if there's a preference for those who write regulatory text.
Consistent with?
Consistent with?
Yeah,
Okay.
that's up above, yeah.
Okay. PPRP, any outstanding items for you?
No, sir.
No.
Any outstanding items for any of the stakeholders on the call?
Excuse me, Mr. Chairman, Chris Drummond. This is a bit off topic, though perhaps I wish it wasn't. The rulemaking exercise is focused almost exclusively on the beginning of the process, and that is how an applicant might a completed application, and then what happens between completeness determination and the commencement of the merits portion of the CPC and application process. In some conversations with Mr. Chen, I've suggested that perhaps the rulemaking exercise should consider that which occurs during the process and afterwards. I'm only going to touch on one. Those conversations have not produced suggested rulemaking for what happens during the process and what happens following CPC and approval. One matter that has come up consistently, though, that I hope, while it might not be addressed in this rulemaking exercise, would be addressed promptly by the Public Service Commission. And that has to do with the submission of decommissioning plans to satisfy a condition of CPC and approval. The decommissioning plans we are finding are submitted to the Public Service Commission unless the locals are bird dogging the PCS's website. The counties don't tend to see them until grading permits or sediment erosion control permits, those sorts of things are requested at the very end of the when construction is imminent. For example, I learned recently that the Bluegrass Solar decommissioning plan was approved by the Public Service Commission on March 4th of 2020. We saw it for the first time in the county less than a month ago. One could say that we should have been more diligent in reviewing the docket for the Public Service Commission. And while Queen Anne's County and Dorchester County may be more advanced, and Frederick County more advanced in the bird dogging Public Service Commission proceedings, other counties and towns are not. I would ask that you give some consideration to a requirement that an applicant submit a decommissioning plan to the local jurisdiction at the same time it is produced to the Public Service Commission in satisfaction of a CPCN application approval. Problem, for example, with just using Bluegrass Solar, it, like a number of other recent decommissioning plans, was approved by the Public Service Commission with less than 10, with the financial security that was approved is less than 10% of the cost of the estimated cost of decommissioning on the salvage value concept, which I've argued against unsuccessfully so far. I think we're kind of stuck with it. I'm not sure what the county can do that's different than what was approved by the Public Service Commission without, I don't know what the applicant would do if we said, well, now we don't want your 10% financial security. We think you should post something greater than that. If we had been involved up front, maybe something different would have occurred. So I understand it's a bit off topic, but I hope it's something that will be addressed soon. Thank you.
Thank you, Mr. Drummond. That concern is outside of the scope of this rulemaking proceeding, although it's one that you brought to our attention previously, and it's noted. Any other issues from stakeholders? Any other issues from commissioners? At this point, I will take appearances from any parties that have not already made an appearance on the record. Seeing none, I will be prepared to make a motion, and it will be a global motion on all the regulations that we've addressed, modified, and approved over the course of the past 2 days. Commissioners may have made individual objections to specific proposed regulations, including Commissioners Richard, Commissioners O'Donnell, and Commissioner Herman. These objections are noted for the record. At this time, I move that the Commission publish the following proposed revisions to its existing regulations as filed by the Commission staff in docket RM72 on December 18, 2020, and as amended during the course of this rulemaking session. In the Maryland Register, for notice and comment, subject to non-substantive changes necessary to conform to COMAR drafting requirements. The proposed revisions and additions to COMAR are to Title 20, Subtitle 79, Chapter 1, Regulation 2, 5, 6, 8, 10, and 11, Chapter 2, Regulation 1 and 2, Chapter 3, Regulation 1, 2, 3, and 4. The vote begins with Commissioner Herman.
I vote aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Not wishing to make the perfect the enemy of the good, I vote aye, Mr. Chairman.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved and the proposed regulations will be published in the Maryland Register. I'd like to recognize that we've made a lot of progress, I think, over the past 2 days. This will reflect a sea change in the level of outreach that will be made to our local governments, including the municipalities and the county officials. I recognize that the parties have worked very hard since September to reach either consensus or near consensus on many of these items. I'd like to particularly thank Joey Chen for leading this effort along with the staff team, as well as the counties and municipalities that participated. As I stated earlier in this proceeding, we're often only seeing Montgomery County in most of our proceedings, but I'm glad that Frederick, Kent, and Queen Anne's have participated along with MACO and MML. And of course, the developers and those in the community, including Ms. Christian Lewis, who have expressed interest in being a stakeholder and being made aware of these projects that are happening in our backyards and our counties. If and when these proposed regulations are finalized, I think it will go a long way towards promoting more outreach and building better projects for our state in meeting our clean energy goals. With that, with no additional matters before the commission today, this rulemaking session is now adjourned.